right, great. So today we're here with Sarah from Agee, Clymer, Mitchell, and Portman, and we're going to discuss her specialty. Just know that this is for educational purposes and not meant to establish an attorney-client relationship, nor is it construed as legal advice because each situation is different. But if you are interested, you can reach out to Agee Clymer, and the contact information is in the comments below. Good morning, Sarah. How are you?
How are you today?
All right, good, good. I wanted to jump into it because I had some misconceptions in the beginning of what phase you came in at. And we established that it was generally, well, there are exceptions, but generally it's when they get that denial letter for Social Security benefits. So I wanted to start by asking, how common is it for legitimate Social Security claims to be denied the first time?
It's unfortunately very common, and that's nothing against the agency. There's a number of very talented, hardworking individuals doing all they can, but the volume is exceedingly high, and there are things that get missed. And so, if they aren't able to access a complete record of your doctor's notes, these appointment records are critical. If they can't make heads or tails of what your doctors are saying, if they need more information, if a form is dropped somewhere along the process, a denial can occur even with an extremely favorable case.
So you're saying when someone receives a denial letter, there are some common reasons you see even when the person truly can't work. Could you,
Absolutely.
yeah.
And sometimes it's a matter of communication. Sometimes it's just a matter of persistence. We see frequently very strong cases that just need that extra assistance.
So it's a lot around the documentation and the technicalities of the procedure.
And unfortunately, who's looking at it, what phase of the case you're in, there's a lot of factors that play into getting an approval.
So are those, for big technical terms, are those called technical and evidentiary gaps, or is it just a processing process of, like you said, just having the maybe secondary people looking at the file instead of the top-notch processors?
Could be both. And frequently at the initial level, the decision's made by the agency that has a very high volume of cases in front of them. And we find the best chance for success if you've received an initial denial is then going up to a hearing level. And that's something that understandably causes a great deal of anxiety for a lot of our clients. But with the right assistance, the right approach, we can minimize that stress and turn a hearing into really an opportunity. It's the first chance along the process from initial through reconsideration through hearing where you're actually able to speak with the person making the decision in your case, handling your medical records, and getting your perspective in terms of how your health is affecting your day-to-day life. And so that's why I feel like the hearing level is typically, and the data backs that up across the nation, the most beneficial step in the hearing process. And that's when people really turn to legal experts for advice. They don't want to go in by themselves to have a hearing in front of an administrative law judge. So whether you're denied at initial, whether you're denied at reconsideration, having the opportunity to have someone like AG Clymer step in and really shepherd through that process and make sure the right questions get asked and make sure that we're there with you during a hearing can make a difference.
So what you're saying is that maybe there's a difference between proving a diagnosis and proving disability under Social Security rules?
Absolutely, yes. You can have a diagnosis, you can have an x-ray showing a concern, you can have a knee surgery, you can have all of the evidence in the world, but until the right decision maker truly understands what impact that has in your day-to-day life. Can you go grocery shopping independently? Can you go back to do the work that you used to do? Is it limiting you in terms of your concentration, your pain? All these factors being spelled out and painting the picture in terms of what your health is causing your day-to-day life experiences to suffer, those pain points and stressors and aggravations, that's something that a conversation with an attorney can really tease out in a beneficial way during a hearing.
So it seems like your law firm simply doesn't like rebuild a denied case differently and refile and submit the paperwork. You're getting under the hood so that if there is a reversal and you're approved, it's under with the right conditions.
Absolutely. We'll work with you. We'll work with your doctors. We'll make sure Social Security is looking at the right evidence and coming to the right decision.
Now, I know that with workman's comp, there is some technical filing deadlines, and it changed recently, but I think it's a year. Is there an overlay of filing deadlines with Social Security?
There's definitely deadlines. So when our most common case has happened right after that initial denial, that's when most people start reaching out. It's obviously, as you mentioned, not initially the case. Some of our clients are our workers' compensation clients, and we can be engaged immediately. Some of our clients come to us after a hearing's already been scheduled and they realize I want a little bit of additional support. But the most common situation we see is somebody who's filed, they have a legitimate claim, but they've received a denial from Social Security. And they reach out to us and say, let's get you involved. Let's have you step in, help me with the next steps through here. And we have the ability to then get to know that person. Make sure their appeals filed in a timely fashion because that initial denial in our most common scenario, that initial denial comes with a 60-day deadline. And that is something that we have to be extremely mindful of. So at each stage, at each decision, there is definitely a critical time moment to respond within. So if you have received a denial, I do suggest that you look around at what your options are and contact someone as soon as possible if you think you're going to need a representation.
So there is a point where waiting too long can hurt your chances for sure.
It can. There is a point where if you're past a deadline, you may need to refile, you may need to resubmit. We can help discuss that, but it's very advisable to seek help as soon as you know you need it.
Now, if someone watching this already has been denied and feels overwhelmed, what's the smartest next step they can take?
So I would say gather your information. Make sure Social Security is really getting the full picture here. So get together a list of who your doctors are, get together a list of the medications that you're taking, make sure they've factored in all of the concerns that your health is causing, whether it's physical or mental health. Everything's important. And then I would suggest if you do contact AG Clymer or another firm, have that denial letter with you because as you mentioned, there is that timing to it. So if you've been denied, make sure you've got a full copy of that letter with the date it was sent out because that's going to trigger a response deadline.
Now, will these doctors be involved or other vocational experts and functional limitations corroboration? Is that part of the
Yeah.
process?
Yeah. So Social Security does have their own medical experts that they frequently send applicants out to. So you may be asked to go to a consultative evaluation. Obviously, Social Security's doctors aren't treating you. They're seeing you for a brief period just to do that exam and that evaluation. So they don't get to know you the way your doctors do. If you have a medical professional who's had that conversation with you, I don't think you should be going back to work or has given you any kind of restrictions in terms of lifting, in terms of someone in your corner that through their relationship with you really understands your care, those medical professionals can play a huge role if they're willing to complete a statement. Our office sometimes engages with them to see if they'll complete some paperwork for us. Anything that they can do to put into even your treatment notes, documenting, if your gait is antalgic, if you have lifting restrictions, if they've told you after a heart event to elevate your legs, make sure they're documenting that in your treatment notes so that Social Security can see the advice that they're telling you you need to follow in your day to day life.
So it sounds like you've done this before, and that is
We
very
have.
reassuring. So, how does your familiarity with administrative law judges influence how you prepare and present cases?
Each judge runs their courtroom a little bit differently. And so we do try and get a feel for what's the most effective case. There are some judges that we appear in front of that are very interested in seeing your page citations to specific pinpoint places within medical records. There are some that are very interested in having an opening statement where I'm able to say 5 or 6 sentences about why I feel my clients deserve these benefits. There's some judges that skip right over that into just having that dialogue directly with the person involved. And so they'll start asking my clients a number of questions. And I always take the time for every case, whether it's with a judge that I've had 100 times, my client hasn't. And so for each hearing, I try and schedule a pre-hearing conversation 7 to 10 days out from the hearing itself. So not so far in advance. Happy to answer questions anytime, but not so far in advance that we've forgotten what we're talking about, and not so close in time that you're just spending the weekend beforehand getting increasingly nervous. So I've found over time that 7 to 10 day mark is a real sweet spot to have a dialogue about what the hearing's going to be, really from beginning to end. From the start of when they call you or when we arrive in the hearing office, who you're going to be interacting with, what kinds of questions the judge will have for me, the kinds of questions I'll have for you, because when the judge is done talking to my client, then I have an opportunity to ask those follow up questions and make sure that we've really explained everything and make sure that the judge hears everything that's going to be important for the case. And then what happens towards the end in adult cases where the judge has the opportunity to talk to a vocational expert, what the whole process is going to be like, feel like, and make sure my clients have that expectation. I feel like that comfort level really enables them to step forward and be a great witness on their behalf. And so I really like engaging in that dialogue. Honestly, my phone call about the hearing takes longer than the actual hearing because we really get into the weeds in terms of some practical advice, what to say, what not to say, and just some advice on how to navigate the process. If you do need to take a break, if you need to take a breath, what kind of support we can provide during the hearing itself. I feel like that comfort level really produces an atmosphere where our conversation then goes smoothly.
That sounds a great balancing of education, the process, and educating that day. Like you said, most court cases are quicker than all the preparation. And much like you're preparing for a deposition or a witness, they're their own witness there, and they might be the one that the judge relies on predominantly. So very good
Absolutely.
stuff.
Your doctor's medical evidence is going to be the heart of the decision in your case, but your doctors don't follow you home. And so they don't see struggling to unload the grocery cart. They don't see how often your sleep is disrupted. They don't see what a struggle it is to even leave your house at times. And so being able to have that conversation with my client at a hearing, painting that complete picture for the judge, I think is really powerful.
Makes sense. Now, could you explain the differences between SSDI and SSI, even explaining what those acronyms are?
Absolutely. So SSD and SSI have the same medical requirements. So, whether this is a child's case, whether you're a young adult, whether this is somebody who's in their 50s and just cannot do the work that they used to do, the medical standard for SSI and SSD are the same. The difference are the financial requirements, both what you're eligible for to receive and the requirements you have to meet to be able to apply. And so that's the difference you're going to see when you file an application. SSD is based on your work credits. And so if you have worked and paid into the system, you've paid in quarters at a time, Social Security is going to be able to cover you for SSD if you've worked enough in your lifetime and if your work has been recently enough to when you became unable to go back to work because of your health. So you have to be fully insured. You have to have earned enough credits and you have to have experienced the medical concern within the time frame where you're still insured for it. Almost like a life insurance policy. You have to pay it and then it does expire over a certain period of time. So you have to have either you or in some rare situations, a spouse could have made you eligible for SSD through their work credits. If your disability has occurred at a very young age, there's a chance that your parents, once they become themselves disabled or they retire, their work credits could be applied to a very young adult who has medical concerns making them unable to earn their own work credits. So SSD is really based on someone paying into the system. SSI, on the other hand, is a financial needs based program. So if you've never been able to work, or if it's been a long time since you've been able to work, and you don't have any other source of income. There isn't a household income coming through. You don't have a number of other assets that you could live off of. If you have that true financial need, SSI is a program to have that Social Security safety net. Same thing with children. So if your disabled family member is 7, 10 years old, those kids' cases are financial needs based. They take into account the familial circumstances. If there is a financial need there and a child's health keeps them apart from their peers in a key area, whether it's academic success or whether it's their own health and mobility concerns, that is handled under the SSI standard as well.
Well, that's good. So we were prepping for this call before, I had the connotation of Social Security meaning a retirement. And so what you're saying about these age ranges, it's totally separate, even though it's with that same department. Could you just elaborate on that?
Absolutely. Retirement, similar to SSD, is going to be based on the work credits that you pay in as you move towards your career. But if you're under the age of 65 and your health is stopping you from work, whether you've ever had success there or not, there are these programs, SSD and SSI, that can step in and provide that safety and stability within your family Monthly payments are key for my clients when they're no longer able to financially provide for themselves. And each of those benefit programs comes coupled with health insurance. So if you are SSI eligible, you could be eligible to receive Medicaid. If you're SSD eligible and you've been eligible for the program for at least 2 years, you could be receiving Medicare. And so having that insurance protection as well, particularly for individuals with disabilities, is key as you step through. That's something that we really fight for.
Now, is there something like with personal injury and insurance companies that once there's an award, they want to get paid back for back things, and as a part B to that award is can it be revoked or is it permanent?
So it's not permanent if you are approved for disability. Every person in pay status does go through a process of continuing disability review. And Social Security sets how often they circle back on your case. It could be 3 years, it could be 7 years. It just depends on how permanent they think your conditions are, how likely you are to see medical improvement. And with that process, I will say, I know we've just scratched the surface here. It is a lot easier to stay on benefits once you're on them than it is to receive them in the first place. Most of the people contacting us are people facing severe medical challenges that are not receiving any benefits right now. But there are cases where we've seen Social Security come in and say, we think you've improved. We think you've improved to the point where you could work. And that's simply not the case. So I would always encourage somebody who's on benefits to continue to stay in touch with Social Security. Know who your doctors are. If your family doctor changes, know about when that occurred. If you go through a series of testing or you have a new MRI or you have a new specialist, know about when that doctor change happened or when that test occurred, when your surgical intervention stepped in, because eventually Social Security is going to circle back with some paperwork. Make sure they have your contact information. So if you move, if you change your address, make sure you change that with Social Security as well, so that nothing falls through the cracks and that you retain the benefits that you worked so hard to achieve.
So is there a demarcation between temporary and permanent disability, or even permanent disability can be reviewed?
So, unlike workers' compensation, Social Security does not have temporary disability. To qualify for Social Security, this has to be something that is expected to last at least 12 consecutive months. So, this is something that isn't a trauma, a quick injury that's expected to resolve that keeps you out of the workplace for 3 months, 6 months. That's what a long term disability or short term disability case is primarily focused on. That's something that a colleague of mine can handle. But for my world, for Social Security, they are looking at something that really takes you out for at least 12 consecutive months of a workplace setting or a condition that you might be struggling with on a lifelong basis. So they also don't award a partial disability standard. I know with workers' comp, we might have something where it's 15%, it's 20%. Here we're looking at you're either qualified for disability benefits or you're not. They're not going to say you're half disabled. So we're looking at something that is a long impact for something that is going to result in a full payment of benefits. And I have had, thankfully, some clients who have had significant conditions. I'm thinking of cancer in particular, where your treatments, those side effects may take you out for at least 12 consecutive months. And then thankfully, with medical assistance, you're able to gradually improve. Or I think of my cardiac rehabilitation success cases where they've had a massive medical event. It's taken them out of the workplace for more than a year, but through diligent cardiac rehabilitation, they've been able to reestablish themselves. Those cases, even if they're not resolved by the time you return to work, so long as you've been out for 12 consecutive months, you could be looking at a closed period of back pay benefits to cover that lengthy time, longer than short term or long term disability benefits might cover you for.
Excellent. And I know that might have seemed obvious to you on the surface, but I'm trying to cover basis. You brought up some medical conditions. Are there other medical conditions, including maybe the advent of mental conditions that you've seen increase or even covered?
Yeah. Mental health plays a huge impact for my clients' lives. And so when I talk about health, I'm not just speaking of physical health. It's physical health, it's mental health. Often it's both because often, a client who suffers an injury at work, that is huge change in their life and something that they struggle to cope with. Understandably, someone struggling with anxiety over their circumstances, massive loss, could be dealing with some post traumatic stress issues. These are factors that Social Security need to hear about. So if you've been denied and they haven't fully factored in all aspects of your health, whether it would be something that even standing alone might not qualify you, we want to be sure that they're hearing from your doctors that you're receiving the right care from both a mental and a physical health perspective. For cases that you're dealing simply with standalone physical health or standalone mental health, those can also be valid claims too, but frequently it's both.
Makes sense. And one last obvious question. There's no cost to for consultation or even throughout the process. Do you work on contingency like the other departments?
We do. If you need to speak with somebody, a timer and taking care of billing you and invoicing you just for calling our office. There's never a charge for intake. You can give us a call anytime. And as the process goes, if you are approved, we do not get a piece of your ongoing monthly payments. That's something that is retained fully by my clients. If you're approved, Social Security will also calculate the time from when they should have started paying you to when those monthly benefits kick in. And that back pay payment, usually pegged around the application date, that back pay window, Social Security is able to retain 25% of it for our attorney's fees. So if we're successful and we receive back pay payment, 75% of it would go to my client. 25% of it would go to our firm for our services. And then if there's ever any outstanding out of pocket expenses, if we have to work with your doctor and prepay for a test, something like that, it's extraordinarily unusual. I would say 95% of the time, we don't have an invoice at the end of a case. This is something where if you're an Ohio resident and your doctors have been in Ohio, we can, under our state law, get copies of those medical records for free under Ohio Revised Code sections. So every once in a while, I see somebody who, they are from Ohio, but they were injured in like Hilton Head, and they come back. We request those out of state records. We will eventually pass those costs on to you, but 95% of the time, it's on that contingency fee basis.
Excellent. Well, a lot of good information here, and I appreciate you taking the time to explain that. Is there anything else that you would, if you could talk to anybody that's listening, that's, like you said, just opened this letter or just got that email, to take them through what that call looks like briefly, and just to fill in the gaps so they know that there's absolutely no risk, obligation, you're not going to hurt anything. What could they expect during that initial call?
Absolutely. So I'd say the key piece is to not ignore it. I know bad news and harsh realities and that anxiety when that letter opens up and now what are you going to do? Oftentimes people want to set it down in that mail pile and step away from it and forget about it for 3 weeks. I would encourage you to pick up the phone and call for help because the sooner you reach out to us, the easier it is for us to get engaged. Make sure you've got that letter with you. Make sure we know the date on it because as you mentioned earlier, the clock starts ticking with an appeal and we want to be sure that we're timely. We would contact you. We'd set up a time to talk. You'd be able to call in, give us some information and some basic information. How long has it been since you've been able to work? What medical concerns are you having that's really led you to file here? Some information about you, just so that we know that we're a good fit for you. You know that you're in the right place. We want to make sure you've got options. We want to make sure you've got the time to see that, we are a good fit for you. We'd have the option then to send you out some new client paperwork, some forms, that fee agreement that we discussed, the appointment of representation, some paperwork that Social Security will need for us to process on your behalf. We'd mail it to you. You'd be able to send it back to us after both of us know that we're a good fit together. So I like having those introductory phone calls as well, just to make sure that we think that your case is something that we can provide value to, that we can move the ball forward with you on. So don't hesitate. Go ahead and reach out, give us a call. There's no pressure with it.
Well, one last thing. You said move the ball forward. I'd like to say go Bucks in the upcoming
Absolutely.
playoffs. And we appreciate your time. And anybody that is listening, the information will be at the bottom, but it's available at agclymer.com.